Constitution of India, Part 12, Finance, Property, Contracts and Suits. Chapter 1, Finance, Article 264 to 290A. General. Article 264, Interpretation. In this part, Finance Commission means a Finance Commission constituted under Article 280. Article 265, Taxes not to be imposed save by authority of law. No taxes shall be levied or collected except by authority of law. Article 266, Consolidated Funds and Public Accounts of India and of the States. Subject to the provisions of Article 267 and to the provisions of this chapter, with respect to the assignment of the whole or part of the net proceeds of certain taxes and duties to states, all revenues received by the Government of India, all loans raised by that government by the issue of treasury bills, loans, or ways and means advances, and all monies received by that government in repayment of loans shall form one consolidated fund to be entitled the Consolidated Fund of India. And all revenues received by the government of a state, all loans raised by that government by the issue of treasury bills, loans, or ways and means advances, and all monies received by that government in respect of loans shall form one consolidated fund to be entitled the Consolidated Fund of the State. All other public monies received by or on behalf of the Government of India or Government of a state shall be credited to the public account of India or the public account of the state as the case may be. No monies out of the Consolidated Fund of India or the Consolidated Fund of a state shall be appropriated except in accordance with law and for the purposes and in the manner provided in this Constitution. Article 267, Contingency Fund. Parliament may by law establish a contingency fund in the nature of an interest to be entitled the Contingency Fund of India, into which shall be paid from time to time such sums as may be determined by such law, and the said fund shall be placed at the disposal of the President to enable advances to be made by him out of such fund for the purposes of meeting unforeseen expenditure pending authorization of such expenditure by Parliament by law under Article 115 or Article 116. The legislature of a state may by law establish a contingency fund in the nature of an interest to be entitled the Contingency Fund of the state, into which shall be paid from time to time such sums as may be determined by such law, and the said fund shall be placed at the disposal of the governor of the state to enable advances to be made by him out of such fund for the purposes of meeting unforeseen expenditure pending authorization of such expenditure by the legislature of the state by law under Article 205 or Article 206. Distribution of revenues between the Union and the states. Article 268, Duties levied by the Union but collected and appropriated by the states. Such stamp duties as are mentioned in the Union list shall be levied by the Government of India but shall be collected in the case where such duties are levied within any Union territory by the Government of India, and in other cases by the states within which such duties are respectively leviable. The proceeds in any financial year of any such duty leviable within any state shall not form part of the Consolidated Fund of India, but shall be assigned to that state. Article 269. Taxes levied and collected by the Union, but assigned to the states. Taxes on the sale or purchase of goods and taxes on the consignments of goods except as provided in Article 269A shall be levied and collected by the Government of India, but shall be assigned and shall be deemed to have been assigned to the states on or after 1st day of April 1996 in the manner provided in Clause 2. Explanation. For the purposes of this clause, the expression taxes on the sale or purchase of goods shall mean taxes on sale or purchase of goods other than newspapers where sale or purchase takes place in the course of interstate trade or commerce. The expression taxes on the consignment of goods shall mean taxes on the consignment of goods, whether the consignment is to the person making it or to any other person, where such consignment takes place in the course of interstate trade or commerce. The net proceeds in any financial year of any such tax, except insofar as those proceeds represent proceeds attributable to the Union territories, shall not form part of the Consolidated Fund of India, but shall be assigned to the states within which the tax is leviable in that year, and shall be distributed among those states in accordance with such principles of distribution as may be formulated by Parliament by law. The Parliament may by law formulate principles for determining when a sale or purchase of or consignment of goods takes place in the course of interstate trade or commerce. Article 269A. Levy and collection of goods and services in course of interstate trade or commerce. Goods and services tax on supplies in the course of interstate trade or commerce shall be levied and collected by the Government of India, and such taxes shall be apportioned between the Union and the states in the manner as may be provided by Parliament by law on the recommendations of Goods and Services Tax Council. Explanation. For the purposes of this clause, supply of goods or of services, or both in the course of import into the territory of India, shall be deemed to be supply of goods or of services, or both in the course of interstate trade or commerce. The amount apportioned to a state under Class 1 shall not form part of the Consolidated Fund of India. Where an amount collected as tax levied under Class 1 has been used for payment of the tax levied by a state under Article 246A, such amount shall not form part of the Consolidated Fund of India. Where an amount collected as tax levied by a state under Article 246A has been used for payment of the tax levied under Class 1, such amount shall not form part of the Consolidated Fund of the state. Parliament may, by law, formulate the principles for determining the place of supply, and when a supply of goods or services, or both, takes place in the course of interstate trade or commerce. Article 270. Taxes levied and distributed between the Union and the states. All taxes and duties referred to in the Union list, except the duties and taxes referred to in Article 268 and 269 and 269A, respectively, surcharge on taxes and duties referred to in Article 271, and any cess levied for specific purposes under any law made by Parliament shall be levied and collected by the Government of India, and shall be distributed between the Union and the states in the manner provided in Class 2. The tax collected by the Union under Class 1 of Article 246A shall also be distributed between the Union and the states in the manner provided in Class 2. The tax levied and collected by the Union under Class 2 of Article 246A and the Article 269A, which has been used for payment of tax levied by the Union under Class 1 of Article 246A, and the amount apportioned to the Union under Class 1 of Article 269A, shall also be distributed between the Union and the states in the manner provided in Class 2. Such percentage as may be prescribed for the net goods of any such tax or duty in any financial year shall not form part of the Consolidated Fund of India, but shall be assigned to the states within which that tax or duty is leviable in that year, and shall be distributed among those states in such manner and form, such time as may be prescribed in the manner provided in Class 3. In this article, prescribed means until a finance commission has been constituted, prescribed by the President by order, and after finance commission has been constituted, prescribed by the President by order after considering the recommendations of the finance commission. Article 271. Surcharge on certain duties and taxes for purposes of the Union. Notwithstanding anything in Article 269 and 270, Parliament may at any time increase any of the duties or taxes referred to in those articles except the goods and services tax under Article 246A by a surcharge for purposes of the Union, and the whole proceeds of such surcharge shall form part of the Consolidated Fund of India. Article 273. Grants in lieu of export duty on jute and jute products. There shall be charged on the Consolidated Fund of India in each year as grants in aid of the revenues of states of Assam, Bihar, Odisha, West Bengal, in lieu of assignment of any share of the net proceeds in each year of export duty on jute and jute products to those states such sums as may be prescribed. The sums so prescribed shall continue to be charged on the Consolidated Fund of India so long as any export duty on jute or jute products continues to be levied by the Government of India, or until the expiration of 10 years from the commencement of this Constitution, whichever is earlier. In this article, the expression prescribed has the same meaning as in Article 270. Article 274. Prior recommendation of President required to bills affecting taxation in which states are interested. No bill or amendment which imposes or varies any tax or duty in which state are interested, or which varies the meaning of the expression agricultural income as defined for the purpose of the enactment relating to an income tax, or which affects the principles on which, under any of the foregoing provisions in this chapter, monies are or may be distributable to states, or which imposes any such surcharge for the purposes of the Union, as is mentioned in the foregoing provisions of this chapter, shall be introduced or moved in either House of Parliament, except on the recommendations of the President. In this article, the expression tax or duty in which states are interested means a tax or duty, the whole or part of the net proceeds whereof are assigned to any state, or a tax or duty by reference of the net proceeds whereof sums are for the time being payable out of the Consolidated Fund of India to any state. Article 275. Grants from the Union to certain states. Such sums as Parliament may by law provide shall be charged on the Consolidated Fund of India in each year as grants in aid for the revenues of such states as Parliament may determine to be in need of assistance, and different sums may be fixed for different states, provided that there shall be paid out of the Consolidated Fund of India as grants in aid for the revenues of a state such capital and recurring sums as may be necessary to enable that state to meet the cost of such schemes of development as may be undertaken by the state with the approval of the Government of India for the purpose of promoting the welfare of the scheduled tribes in that state, or raising the level of administration of the scheduled areas therein to that of the administration of the rest of the areas of that state. Provided further that there shall be paid out of the Consolidated Fund of India as grants in aid of the revenues of the state of Assam sums capital and recurring equivalent to the average excess of expenditure over the revenues during the 2 years immediately preceding the commencement of this Constitution in respect of the administration of the tribal areas specified in Part 1 of the table appended to paragraph 20 of the 6th schedule, and the cost of such schemes of development as may be undertaken by the state with the approval of the Government of India for the purpose of raising the level of administration of the said areas to that of the administration of the rest of the areas of that state. On the form of the formation of the autonomous state under Article 244A, any sums payable under Class A of the second proviso to Class 1 shall, if the autonomous state comprises all of the tribal areas referred to therein, be paid to the autonomous state, and if the autonomous state comprises only some of those tribal areas, be apportioned between the state of Assam and the autonomous state as the President may by order specify. There shall be paid out of the Consolidated Fund of India as grants in aid of the revenues of the autonomous state sums, capitals, and recurring equivalent to the cost of such schemes of development as may be undertaken by the autonomous state with the approval of the Government of India for the purpose of raising the level of administration of that state to that of the administration of the rest of the state of Assam. Until provision is made by Parliament under Clause 1, the powers conferred on Parliament under that clause shall be exercisable by the President by order, and any order made by the President under this clause shall have effect subject to any provision so made by Parliament, provided that after a Finance Commission has been constituted, no order shall be made under this clause by the President except after considering the recommendations of the Finance Commission. Article 276. Taxes on professions, trades, calling and employments. Notwithstanding anything in Article 246, no law for the legislature of a state relating to taxes for the benefits of the state or of a municipality, district board, local board, or other local authority there in respect of professions, trades, calling or employment shall be invalid on the ground that it relates to a tax upon income. The total amount payable in respect of any one person to the state or to any one municipality, district board, local board, or other local authority in the state by way of taxes on profession, trade, callings and employments shall not exceed 2,500 rupees per annum. The power of the legislature of a state to make laws as aforesaid with respect to taxes on professions, trades, calling and employments shall not be construed as limiting in any way of power of Parliament to make laws with respect to taxes on income accruing from or arising out of the professions, trade, callings and employments. Article 277. Savings. Any taxes, duties, cess or fees which immediately before the commencement of this constitution were being lawfully levied by the government of any state or by any municipality or other local authority or body for the purposes of the state, municipality, district or other local area may, notwithstanding that those taxes, duties, cesses or fees as mentioned in the union list continue to be levied and to be applied to the same purposes until provision to the contrary is made by Parliament by law. Article 279. Circulation of net proceeds, etc. In the foregoing provisions of this chapter, net proceeds means in relation to any tax or duty the proceeds thereof reduced by the cost of collection, and for the purposes of those provisions the net proceeds of any tax or duty or of any part of any tax or duty in or attributable to any area shall be ascertained and certified by the Comptroller and Auditor General of India, whose certificate shall be final. Subject as aforesaid, and to any other excess provision of this chapter, a law made by Parliament or an order of the President may, in any case where under this part the proceeds of any duty or tax are or may be assigned to any state, provide for the manner in which the proceeds are to be circulated, for the time from or at which and the manner in which the payments are to be made, for making of adjustments between one financial year and another, and for any other incidental or ancillary matters. Article 279A. Goods and Services Tax Council. The President shall, within 60 days from the date of commencement of this Constitution, 101st Amendment Act 2016, by order constitute a council to be called the Goods and Services Tax Council. The Goods and Services Tax Council shall consist of the following members, namely the Union Finance Minister, Chairperson, the Union Minister of State in charge of Revenue or Finance, member, the Minister in charge of Finance or Taxation or any other minister nominated by the state government, member. The members of the Goods and Services Tax Council referred to in subclass C of class 2 shall as soon as may be chosen one amongst themselves to be the Vice Chairman of the Council for such period as they may decide. The Goods and Services Tax Council shall make recommendations to the Union and the States on the taxes, cesses, surcharges levied by the Union, the States and the local bodies which may be subsumed in the goods and services tax. The goods and services that may be subjected to or exempted from the goods and services tax. The model goods and services tax laws, principles of levy, apportionment of goods and services tax levied on supplies in the course of interstate trade or commerce under Article 269A, and the principles that govern the place of supply. The threshold limit of turnover below which goods and services may be exempted from goods and services tax. The rates including floor rates with bands of goods and services tax. Any special rate or rates for the specified period to raise additional resources during any natural calamity or disaster. Special provision with respect to the states of Arunachal Pradesh, Assam, Jammu and Kashmir, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura, Himachal Pradesh and Uttarakhand. And any other matter relating to the goods and services tax as the council may decide. The Goods and Services Tax Council shall recommend the date on which the goods and services tax will be levied on petroleum crude, high-speed diesel, motor spirit, commonly known as petrol, natural gas, and aviation turbine fuel. While discharging the functions conferred by this article, the Goods and Services Tax Council shall be guided by the need for a harmonized structure of goods and services tax and for the development of a harmonized national market for goods and services. On half of the total number of members of the Goods and Services Tax Council shall constitute the quorum at its meetings. The Goods and Services Tax Council shall determine the procedure in the performance of its function. Every decision of the Goods and Services Tax Council shall be taken at a meeting by a majority of not less than 3/4 of the weighted votes of the members present and voting, in accordance with the following principles, namely, the vote of the central government shall have a weightage of 1/3 of the total votes cast, and the votes of all state governments taken together shall have the weightage of 2/3 of the total votes cast. In that meaning, no act or proceedings of Goods and Services Tax Council shall be invalid merely by reason of any vacancy in or any defect in the constitution of the council, or any defect in the appointment of a person as a member of the council, or any procedural irregularity of the council not affecting the merits of the case. The Goods and Services Tax Council shall establish a mechanism of adjudicate any dispute between the Government of India and one or more states, or between the Government of India and any state or states on one side and one or more states on the other side, or between two or more states arising out of the recommendations of the Council or implementation thereof. Article 280, Finance Commission. The President shall, within 2 years from the commencement of this Constitution, and thereafter at the expiration of every fifth year, or at such earlier time as the President considers necessary, by order constitute a Finance Commission, which shall consist of a chairman and 4 other members to be appointed by the President. Parliament may, by law, determine the qualifications which shall be requisite for the appointment as members of the Commission and the manner in which they shall be selected. It shall be the duty of the Commission to make recommendations to the President as to the distribution between the Union and the states of the net proceeds of tax which are to be or may be divided between them under this chapter, and the allocation between the states of the respective shares of such proceeds. The principles which should govern the grants in aid of the revenues of the state out of the Consolidated Fund of India. The measures needed to augment the Consolidated Fund of a state to supplement the resources of the panchayats in the states on the basis of recommendations made by the Finance Commission of the state. The measures needed to augment the Consolidated Fund of a state to supplement the resources of the municipalities in the state on the basis of recommendations made by the Finance Commission of the state. Any other matter referred to the Commission by the President in the interest of sound finance. The Commission shall determine their proceeds and shall have such powers in the performance of their functions as Parliament may by law confer on them. Article 281. Recommendations of the Finance Commission. The President shall cause every recommendation made by the Finance Commission under the provisions of this Constitution, together with an explanatory memorandum as to the action taken thereon, to be laid before each House of Parliament. Miscellaneous financial provisions. Article 282. Expenditure defrayable by the Union or a state out of its revenues. The Union or a state may make any grants for any public purpose, notwithstanding that the purpose is not one with respect to which the Parliament or the legislature of the state, as the case may be, may make laws. Article 283. Custody, etc. of the consolidated funds, contingency funds, and money credited to the public accounts. The custody of the Consolidated Fund of India and the Contingency Fund of India, payable to the payment of monies into such funds, the withdrawal of monies therefrom, the custody of public monies other than those credited to such funds, received by or on behalf of the Government of India, their payments into public accounts of India, and the withdrawal of monies from such account, and all other matters connected with or ancillary to matters aforesaid, shall be regulated by law made by Parliament, and until provision in that behalf is so made, shall be regulated by rules made by the President. The custody of the Consolidated Fund of the State and the Contingency Fund of the State, the payment of monies into such funds, the withdrawal of monies therefrom, the custody of public monies other than those credited to such fund, received by or on behalf of the Government of the state, their payment into the public account of the state, and the withdrawal of monies from such account, and all other matters connected with or ancillary to matters aforesaid, shall be regulated by law made by the legislature of the state, and until the provision in that behalf is so made, shall be regulated by the rules made by the Governor of the state. Article 284. Custody of suitors' deposits and other monies received by public servants and courts. All monies received by or deposited with any officer employed in connection with the affairs of the Union or of a state in his capacity as such, other than revenues or the public monies raised or received by the Government of India or the Government of the state, as the case may be, or any court within the territory of India, the credit of any cause, matter, account, or pensions shall be paid into the public account of India or the public account of a state, as the case may be. Article 285. Exemption of property of the Union from state taxation. The property of the Union shall, save insofar as Parliament may by law otherwise provide, be exempt from all taxes imposed by a state or by any authority within a state. Nothing in this clause 1 shall, until the Parliament by law otherwise provides, prevent any authority within a state from levying any tax on any property of the Union to which such property was immediately before the commencement of this Constitution liable or treated as liable, so long as that tax continues to be levied in that state. Article 286. Restrictions as to imposition of tax on the sale or purchase of goods. No law of a state shall impose or authorize the imposition of a tax on the supply of goods or of service, or both, where such supply takes place, outside the state or in the course of the import of the goods or services, or both into or export of the goods or services, or both out of the territory of India. Parliament may by law formulate principles for determining when a supply of goods or services, or both, in any of the ways mentioned in clause 1. Article 287. Exemption from taxes on electricity. Save insofar as Parliament may by law otherwise provide, no law of a state shall impose or authorize the imposition of a tax on the consumption or sale of electricity, whether produced by the government or other persons, which is a consumed by the Government of India or sold to the Government of India for consumption by that government, or consumed in the construction, maintenance, operation of any railway by the Government of India or a railway company operating that railway, or sold to that government or any such railway company for consumption in the construction, maintenance, or operation of any railway, or any such law imposing or authorizing the imposition of a tax on the sale of electricity shall secure that the price of electricity is sold to the Government of India for consumption by that government or to any such railway company as aforesaid for consumption in the construction, maintenance, and operation of any railway shall be less by the amount of the tax than the price charged to other consumers of a substantial quantity of electricity. Article 288. Exemption from taxation by states in respect of water or electricity in certain cases. Save in so far as the President may by order otherwise provide. No law of the state in force immediately before the commencement of this Constitution shall impose or authorize the imposition of the tax in respect of any water or electricity stored, generated, consumed, distributed, or sold by any authority established by any existing law or any law made by Parliament for regulating or developing any interstate river or river valley. Explanation. The expression law of a state in force in this clause shall include a law of a state passed or made before the commencement of this Constitution and not previously repealed, notwithstanding that it or parts of it may not be then in operation, either at all or in particular areas. The legislature of a state may by law impose or authorize the imposition of any such tax as is mentioned in clause 1, but no such law shall have any effect unless it has, after having been reserved for the consideration of the President, received his assent, and if any such law provides for the fixation of the rates and the other incidents of such tax by means of rules or orders to be made under the law by any authority, the law shall provide for the previous consent of the President being obtained to marking of any such rule or order. Article 289. Exemption of property and income of a state from union taxation. The property and income of a state shall be exempt from union taxation. Nothing in clause 1 shall prevent the union from imposing or authorizing the imposition of any tax to such extent, if any, as Parliament may by law provide in respect of a trade or business of any kind carried on by or on behalf of the government of a state, or any operations connected therewith, or any property used or occupied for the purposes of such trade or business, or any income accruing or arising in connection therewith. Nothing in clause 2 shall apply to any trade or business, or to any class of trade or business which Parliament may by law declare to be incidental to the ordinary functions of government. Article 290. Adjustment in respect of certain expenses and pensions. Where under the provisions of this Constitution, the expenses of any court or commission or the pension payable to or in respect of the pension who has served before the commencement of this Constitution under the Crown in India or after such commencement in connection with the affairs of the Union or of a state are charged on the Consolidated Fund of India or the Consolidated Fund of a state there. Then, if in the case of charge of the Consolidated Fund of India, the court or commission serves any of the separate needs of a state or the pension has served wholly or in part therein in connection with the affairs of a state, or in the case of a charge on the Consolidated Fund of a state, the court or commission serves any of the separate needs of the union or another state, or the person has served wholly or in part of in connection with the affairs of the union or another state, there shall be charged on and paid out of Consolidated Fund of the state, or as the case may be, the Consolidated Fund of India or the Consolidated Fund of another state, such contribution in respect of the expenses or pension as may be agreed, or as may in default of agreement be determined by an arbitrator to be appointed by the Chief Justice of India. Article 290A. Annual payment to certain deversum funds. A sum of 46 lakhs and 50,000 rupees shall be charged on and paid out of The consolidated fund of the states of Kerala every year to the Travancore Devasam Fund, and a sum of 13 lakhs and 50,000 rupees shall be charged on and paid out of the consolidated fund of the state of Tamil Nadu every year to the Devasam Fund established in that state for the maintenance of Hindu temples and shrines in the territories transferred to that state on the first day of November 1956 from the state of Travancore, Cochin.